Good evening. My name is Gary Darneal. I'm Salem Hearings official. For the record, it's 5:30 on Wednesday, January 14, 2026. This evening we have one hearing on our docket. The hearing concerns a proposed zone change to allow basic utilities and power generation facilities, a Class 3 site plan review, property line adjustment, and a tree regulation variance for tax lot 1804, Marion County Assessor Map 083W0200. The property has a site address of 3750 Fairview Industrial Drive, Southeast Salem, Oregon. The applicant in this matter is Goldfinch Energy Storage, LLC. Will be represented by Emily Ramos of Solar and Storage, US Solar and Storage. This is case number ZC-SPR-TRV-PLA 25-11. Staff will identify the approval criteria during the presentation of the staff report. First, are there any objections to the jurisdiction of the hearings official to hear this matter? Hearing no challenges. Before we actually get into the public testimony portion of the evening, I'd like to explain some of the rules that we follow. These hearings can be characterized as being quasi-judicial and de novo. By quasi-judicial, that means there are certain due process rights that are associated with the hearing. The right to testify, the right to have notice, the right to an impartial decision maker, and the right to a written decision based on findings of fact and conclusions of law. By de novo, that means you can raise any new evidence or approval criteria as long as they're relevant to the application's intent. The rules of evidence in these matters are not as rigid as you'll see in circuit court. Basically, evidence that is admissible is that which a reasonably prudent person would rely upon in conducting their serious daily affairs. It's important to note that before the record closes, you need to raise any procedural or substantive issues at the hearing. Failure to do so will preclude your ability to raise those issues for the Oregon Land Use Board of Appeals. Also, a similar failure to raise constitutional issues relating to the proposed conditions of approval will preclude your ability to bring an action for damages in circuit. The burden of proof in these matters lies, the burden of proof for each factor position lies with the person that raised that factor position. The ultimate burden lies with the applicant to show by a preponderance of the evidence that all approval criteria have been met. The record in this matter includes the application, supplemental materials, staff report, any written or oral testimony you provide today, and if the record is held open, any written materials that were introduced into the record before the record closes. By statute, you have the right to request that the record be held open an additional 7 days. You don't have to give reason for that request, but you do need to make that request before the hearing closes. You also have the right to request a continuance of the hearing. That determination is discretionary with the hearings official. You merely need to show that just holding the record open for a certain period of time is not adequate to cure any prejudice that you feel that you have suffered. Testimony in this matter should be given from the podium to my left. Before you offer your testimony, please state your name for our record. In terms of the procedures, we'll begin with the staff report. We have Mr. Brown this morning, and we'll offer the staff report. Following that, there will be an opportunity for the representatives of the applicant to testify, and then others testifying in support. There's also an opportunity for testimony from neighborhood association. Following that testimony, if there is any, testimony from other interested parties who are not wishing to take a stance as being in favor of or opposed to the application. There's an opportunity for those who wish to testify in opposition. Following all of that testimony, I'll turn to staff and see if Mr. Brown wishes to address any of the issues or questions that have been raised. And finally, after that, there'll be an opportunity for rebuttal or evidentiary summary by the applicant's representative. I try to reach a decision within 10 days. You can appeal my decision to the Salem Planning Commission. You have to file that appeal within 15 days from the date of the mailing of the written decision. The appeal before the Planning Commission is de novo. That means you can raise, again, new issues of law or fact before that body. The Salem Revised Code requires that the decision maker in these matters be impartial. So let me take this opportunity to indicate that I've had no ex parte contacts, nor do I have any actual potential conflicts of interest to declare. At this time, members of the audience may challenge my impartiality, and of course, you can raise those issues throughout the proceedings. Hearing no challenges, Mr. Brown. Yes.
Can I make one correction to the record that this is appealable to city council? The zone change takes
Goes to
precedent.
city council because of the zone change.
Yep. And then I can read the criteria. The applicable criteria for the applicable application is Salem Revised Code, Chapter Quasi Judicial Zone Change 265.005E, Site Plan Review SRC 220.005 F3, Property Line Adjustment SRC 205.055D, and Tree Regulation Variance SRC 808.045D.
And is the appeal period the same? 15 days.
All right. Good evening. I'm Jacob Brown, Planner 2 with the City of Salem Planning Division. At this time, I would like to enter into the record the staff report, all attachments, and this presentation for zone change and Class 3 site plan review, pre-regulation variance, and property line adjustment case number 25-11 into the record.
So accepted.
The applicant, Goldfinch Energy Storage, represented by US Solar and Storage, is requesting a zone change, Class 3 site plan review, tree regulation variance, and property line adjustment for a property located at 3750 Fairview Industrial Drive Southeast. Through the zone change, the applicant is requesting to modify condition 2 of a prior zone change, CPC-Z07-01, to expand the permitted uses to include basic utilities and power generation. Condition 2 limited the uses of the property to Exhibit 1 of the associated decision and did not list the proposed uses for the project. SRC 265.020B requires modification of the use condition to be done through a zone change. No changes to the property zoning or other conditions are proposed with this application. Consolidated with the application is a proposal for development of a battery energy storage system and substation facility which is reviewed through the Class 3 site plan review criteria, tree regulation, and then there's also a tree regulation variance to remove 2 black cottonwoods within the riparian corridor, and a property line adjustment to consolidate the parcels that compose the site. Here is a vicinity map of the area. The properties are combined 7.16 acres in size, composed of 2 distinct parcels. and located within the urban service area. As shown in the aerial of the site, the property butts West Middle Fork of the Pringle Creek to the northwest, and Fairview Industrial Drive southeast to the southwest. Fairview Industrial Drive is classified as a minor arterial in the Salem Transportation System Plan. Abutting the site is Oregon Department of Energy Management and Office of Information Services. A variety of warehousing, distribution, and general manufacturing uses also occupy other sites in proximity to the subject property. To the south and west is a mixture of commercial uses, Fairview Park and residential development within the Fairview mixed use zone, and further down along Fairview Industrial Drive is an additional substation. The subject property has a comprehensive plan map designation of industrial commercial, shown in purple here. Surrounding properties are similarly designated as industrial commercial, with properties to the west and north designated as industrial, shown in gray. To the south are properties under ownership of City of Salem, designated as public open space. You can see in those bottom left-hand corner is indicated as green, and Fairview mixed use development is also located in that south corner there. The property is zoned commercial industrial IC, shown in purple here, with adjoining sites with frontage onto Fairview Industrials being similarly zoned IC, and industrial campus zoning located in that pink color to the north. As shown here, the applicant's site plan outlines the proposed development of the battery energy system and substation. The battery storage areas will occupy the majority of the site, with a substation located along the frontage of Fairview Industrial. Access into the facility will be taken from an existing driveway abutting the eastern portion of the site. The site plan delineates the riparian corridor with the extent shown in green here. The plan also shows 3 blackwoods measuring 3 inches, 21 inches, and 30 inches diameter breast height. Under the Salem Revised Code, any tree with a DBH of 10 inches or more in size or our native vegetation require tree regulation variance when removal is proposed within the corridor. As black cottonwoods are not native to Oregon, only 2 regulation variances are required for the proposed development, as the 3-inch DBH does not rise to the level of being a tree under the Salem Revised Code. All remaining native vegetation and trees indicated within the riparian corridor are to be preserved. There are some additional trees indicated to be preserved within outside of the riparian corridor that do not fall into the significant tree category, which is any tree with a diameter breast height of 30 inches or more, or an Oregon white oak with a diameter breast height of 20 inches or more. Here's also a preliminary landscaping plan of the development, outlining the proposed setbacks and landscaped areas of the site, with a replanting showing the top left corner of the site. Under condition 2 of the prior zone change, development is required to conform with all development standards of the IBC zone as currently amended. The proposed development, as shown here, the proposed development does conform with all the development standards of the IBC zone, such as setbacks, driveway standards, and then also general landscaping that's required. Here's a tentative property line adjustment plan showing the two units of land that compose the site, parcel 1 and parcel 2 of the Fairview Industrial phase 2 plat. The applicant is proposing to consolidate the properties through a property line adjustment to eliminate the common boundary. Notice of the application and public hearing was provided to Morningside Neighborhood Association, and no comments were received. The properties are not located within a homeowners association, and no comments were received from neighboring property owners or tenants at this time. No concerns were raised with other city departments or divisions. As discussed in the staff report and attached as part of the attachments is one comment that was received from the Oregon Department of Aviation, indicating that aeronautical evaluations by FAA and ODAV may be required. The zone change is justified based on the existence of these particular factors. The applicant does not identify a mistake in the application of a land use designation to the property. It does not clearly identify a change in economic, demographic, or physical character of the vicinity. Rather, the proposal is justified on criteria 3, that the proposed zone change to modify the conditions of approval of a prior zone change to expand the allowed uses to include basic utilities and power generation facilities is equally or better suited for the property than existing use limitations. At the time of the Fairview Industrial Park Phase 2 subdivision in 1987, the subject property and surrounding properties were all similarly zoned IBC Industrial Business Campus. Starting in 2007 with a comprehensive plan amendment, the one that's referenced within the staff report. The subject property and properties across the Fairview Industrial Drive changed from industrial designation to the industrial commercial designation. 6 similar cases have subsequently followed this zone change, which created similar changes of properties within the vicinity. These changes have led to the area to develop as more of a commercial business park with light manufacturing / industrial uses. The intent of the industrial commercial comprehensive plan designation is to provide for areas of a mixture of heavy commercial and light manufacturing warehouse activities, while also allowing utility-centered uses. Under the prior zone change in 2007, condition 2 limited the allowed uses of the subject property with the intention of preserving the allowed uses of the IBC, which was established for the large-scale, high-technology electronics manufacturing, while allowing limited commercial uses and light manufacturing. The subsequent zone changes that have occurred in proximity to the site, affecting the area in the IBC zone, did not include a similar condition restricting the uses, and rather elected to just adopt the IC's, the industrial commercial zones allowed uses. Under these prior zone changes, they identified that the character of the area as more of a commercial business park with light manufacturing and industrial uses. The IC zoning shall remain with this proposed zone change, with condition 1 of the prior zone change remaining in effect. That condition required that the development of the property be conform with the industrial business campus zone, which is similar to the prior conditions of approval of the associated zone changes. Analysis of the zone changes consistency with comp plan and the statewide planning goals are listed within the staff report. Condition 1 of the prior zone change required that all development be subject to the development standards of the IBC zone. So under the class 3 site plan review, development standards conforming to the IBC zone were reviewed. The applicant's site plan demonstrates that all development standards will be met. Development Services has determined that the existing street system will provide for the safe and orderly and efficient circulation of traffic to and from the development, and that water, sewer, and storm infrastructure are available and appear to be adequate to serve the proposed development. In regards to the tree regulation variance, the applicant indicates to allow for the construction of the battery storage infrastructure that there's no reasonable design change that would enable the preservation of the Duke black cottonwood trees without impacting the capacity required for the stormwater facility located in proximity to it, or impacting the battery storage infrastructure overall. The applicant has redesigned the proposed grading and development to enable preservation of native vegetation, such as the bitter cherry trees that are located within the riparian corridor, and any other native vegetation located throughout. With the only removal being indicated to be for non-native black cottonwoods and those vegetation that's outside the riparian corridor. Staff agrees that this buffer creates a practical difficulty to reasonably develop the property, as retaining all affected trees within the buffer creates an unreasonable hardship that can be most effectively relieved by approval of a variance. For the property line adjustment, the proposed property line adjustment will consolidate 2 parcels, parcel 2 and 3 of the Fairview Industrial Park Phase 2, resulting in 1 consolidated unit of land. The consolidated unit of land meets all IBC development standards and does not impact any existing easements. In conclusion, staff recommends that the hearings officer approve the zone change, class 3 site plan review, tree regulation variance, and property line adjustment as conditioned. And here are the list of conditions. That concludes my presentation.
Couple of quick questions for clarification. On page 17, I think you talked about this. You addressed the development standards
Mhm.
for the IBC zone. Why are we applying those standards?
Under the prior zone change that we're modifying the condition of, there's condition 1. Which outlined that the IBC zone development standards apply to the subject property.
And then on page 25, you talk about the off-street loading areas. And you make an assumption that the square footage only applies to buildings, is that correct?
Yes.
Okay. Even though the use spreads out, use actually spreads out over almost the entire.
Under 806 of the off-street parking and bicycle and loading area standards. Floor area is used as the means to calculate the required amount.
So,
All right, thank you.
Good evening, everyone. My name is Emily Ramos. I'm a developer at US Solar and Storage Holdings. I'm here representing the project applicant tonight. I'll give you all a quick introduction to the team here. Myself and Kelly McGill over there are here representing Starling Energy Storage, a subsidiary of Goldfinch Energy. DUDEC has provided the land use planning and environmental services. So we have Brad Cole and Tony Vingello. And then we also have with us tonight, Alan Sorum from Saalfeld Griggs. He will be available to answer land use or legal questions if those arise. So Jacob did a really good job with this, so I'll keep this pretty brief, but here's an overview of our project. It is located at 3750 Fairview Industrial Drive in the Fairview Industrial District. The parcel is a little over 7 acres. It's surrounded by similarly zoned parcels, and just down the street is the Hillcrest substation, which is shown down there in the center bottom of that snip. Now here is our proposal. The proposal involves the approval of the consolidated land use application to allow the development of the Starling Energy Storage Project. This would involve approval of 4 items, as Jacob discussed. First, there is the zone change. This involves a modification of a 2007 approval and would allow basic utilities and power generation facilities in this zone and on the site. Important to note that this does not involve changing the underlying zoning. There's also the class 3 site plan review. This would allow for the development of a battery storage facility and the associated substation. There's also property line adjustment. This involves removal of a boundary between 2 adjoining properties to allow for one contiguous property for development. And then lastly, there is the tree regulation variance, which involves removal of 2 trees in the riparian corridor, and along with the associated mitigation activities. So as documented in the staff report, the proposal meets applicable criteria. It's consistent with the industrial commercial zoning, the Salem Comprehensive Plan, and other local land use policies. So we are here today supporting the staff proposal. So in conclusion, we support staff's findings. We accept all of the conditions of approval. We really appreciate all of the time that staff put into putting together the report and the presentation. We also really appreciate the hearing officer's time and are here to answer the questions.
Questions?
Thank you.
Are there others who wish to testify in support of the application? Is there a representative of the neighborhood association who wishes to testify? Are there those who would like to testify but not be identified as being either in favor of or opposed to the application? Is there anyone in the audience who wishes to testify in opposition to this proposal? Final staff comments,
No final staff comments.
a summary by the applicant's representative. Okay. We will close the public hearing then. I will have my decision out no later than Monday of next week. I think the staff report and the applicant's materials were very thorough and made writing a decision fairly straightforward. So thank you for your attendance. We're adjourned.